again so that we can all have access to this at any time. So again, today's schedule, we've got 2 more presentations this afternoon. We're going to talk about copyright for your dissertation, thesis, and report in this section. And then we'll talk about formatting 103, checking and fixing your document next. And then there should be some time left at the end if there's still a burning question that you have. And I will stay here as long as you're here, and includes our online participants. As long as you're here, I will stay here. So don't feel like at 5 o'clock I'm going to run out the door, but definitely available to answer questions. Okay. So again, my name is Deborah Charlesworth, for those of you who are joining us for the first time, and I'm the Assistant Dean of the Graduate School, and I work with students doing dissertation, thesis, or report, and run kind of the process related to that. And so we'll talk again a little bit about finding information and help. If you've been to the 2 previous seminars today, this will be a quick overview again. We'll talk about what copyright is and what it isn't. And I'll give you some really practical examples of real life things students do in their documents and kind of what our best guidance is for you. Talk about then, if you're going to use materials created by others, what you need to do. And we'll also talk about using your previously published papers. I think I've had this question already twice today. It's definitely something we're aware that you're going to ask, so we're going to cover it in this section of the presentation. And then we'll also talk a little bit about fair use. Now, the disclaimer that I have to give you for this presentation is that copyright is a federal law. It's not a graduate school rule, it's a federal law. And so all the stuff that we're talking about today, ultimately, if there's a problem with copyright, if you're doing something, and I think I already started with the sign-in sheet. Is the sign-in sheet going around for copyright? Yeah, okay. It's federal law, and so if there's some reason why your work would be questioned about copyright, the federal government or the court system is going to decide what the kind of the consequences or outcome of that is. So my advice is informational. I am not a lawyer. I don't have legal expertise. I have information to provide to you today. And then parts of this presentation were developed by Nora Allred, who is our copyright librarian at the university, and we've used these materials. So again, if you have any questions at any time, this is for current students. If you are a registered student at Michigan Tech, or even if you're not registered but you're supposed to register in the fall, you can email gradschool@mtu, and we'll be happy to help you at any time. On the web, the important things, if you're on any website in our grad school domain, the policies and procedures area, particularly the forms and deadlines and degree completion timelines, those are going to give you all the information you need about kind of the nuts and bolts of completing your degree. And then the reports and theses and dissertations area will link up to different areas that will help you with formatting and copyright. There's a copyright section on both of those pages. The resources for page has a number of different people, but if you go download the resources for current students page, what I'd like to highlight in the center column today is that the graduate school seminar, which is boxed in red, that's where you'll find the slides for this presentation, as well as additional resources, the videos, additional links, all that kind of stuff will be there. And these will be updated, this presentation will be up there a little bit later this week. So we talked in the last presentation about why you should care about formatting, and we're going to talk about now about why you should care about copyright. Well, first of all, it is a law. And I don't think anybody really intentionally wants to break laws, so that's always a good first start thing to do. It's also the right thing to do. If we're going to talk about copyright, we're talking about reusing materials that were created by somebody else. If we're going to reuse materials created by somebody else, we want to give them the proper attribution, the proper credit, and ask them for permission to do these things if it's appropriate. And your digital documents are being frequently downloaded. People are going to see your work, so you can't rely on, well, nobody's ever really going to see my thesis, so who cares if, you know, I copied something I wasn't supposed to or didn't ask for permission. You know, who cares about that? So people are going to be looking at your documents. One that I looked at yesterday had over 500 downloads in the month of April. I mean, some of our theses and reports are quite popular, and they get downloaded a lot. And if a copyright holder downloads your work and sees their material in there used in an unauthorized way, that could create an issue for you later on. Now today, we're talking about copyright for printed works like a thesis or dissertation or a journal article. There are different rules that exist for reusing materials in the classroom. And often these rules are considered more liberal because if you think about things, if you had a class that was on current events, it wouldn't be very current if you had to wait 6 weeks for permission to use a newspaper article to discuss in your classroom. This doesn't make sense. So there's provisions in the copyright law to allow you to use certain materials that are in the public, in a newspaper and photocopy it for your class. And there's rules about like how much and what you can and how often and all that sort of thing. And they're kind of a little bit more codified. They're a little bit more prescriptive in a good way, in the sense that it's actually very clear and kind of clear cut. What we'll talk about today is a little more fuzzy. So there are rules for that. There are guidelines for that, but that's not something that we're going to talk about today. It's beyond the scope of what we can talk about. So I want to make sure we all sort of know a little bit about what copyright actually is. So I'm going to take a step back and talk about physical property. So physical property is something like a car or a house, maybe my backpack, a piece of equipment. It's like a thing. I can touch it. I can touch this monitor. This is physical property. And there are laws that govern those. So I can't take a car. If I go out in the parking lot and I find a car that has the keys in the ignition, I can't just turn the ignition and drive away. I need permission of the owner to do that. I mean, I could do that, but the cops are going to pull me over and I'm going to get in trouble. I could damage this monitor, but you would all tell somebody, and then I'd be in trouble. And that wouldn't be very good. And there's rules about that. There's a student code of conduct. There are, laws that we have in the government. There's all sorts of things. I can't sell my house without my husband's approval. It's not because he's a mean person, but both of our names are on the deed. So when he goes into the bank and tries to sell the house, he's going to have a hard time doing that because both of our names are on that deed. And I can't damage somebody's property, or at least I can't do it and get away with it if somebody catches me. So there's laws that govern physical property. And physical property is easy to understand because we can see it, we can touch it, we can say it's mine and then somebody else has it and they're not supposed to. Like there's ways to do that. If I have a book with my name in the cover and I find it on somebody else's desk, I can go, that's my book, my name's in the cover, I know this. Now, intellectual property is slightly different. Physical property is physical stuff, but intellectual property is property of the mind. And so that could be, for example, a logo for a company or an idea about how to make something, or the creative expression of an idea like your thesis or your dissertation. Like that is an idea. You creatively expressed the results or the study that you've done or the research. And it's not something that you can always see and touch. I mean, I could touch my thesis, but nowadays, actually, most of the time it's a PDF, right? So I can't really touch that either. It's just some digital document out there. But it's still property. So just like for physical property, there are laws then that govern how intellectual property can be used. So for some kind of radical examples, I mean, I can't take the Nike swoosh and decide that it's my logo for my personal business. I mean, I could, but Nike's going to come after me and go, you can't use our swoosh. Our swoosh is our swoosh. If something's patented, I can't make it without asking permission from the patent holder. If I wrote something, I can't sell it if I didn't write it without asking permission. I can't post music from a rock band on my own personal website and invite my friends and all of their friends to download it. Now, again, I can do all of these things. I mean, there's nothing, obviously, I should say obviously, but there's nothing that prevents me from taking the MP3 in my iTunes music file and putting it on a web server somewhere and saying, hey, friends, come download it. But as soon as the copyright holder finds out, there are going to be consequences for that. Or there could be consequences for that, depending on what you've reused and how you've reused it. So when we talk about intellectual property, there's even a subcategory of what those are. And so there are trademarks. Those would be like your registered, things with a little registered thing next to it. There's patents. So that's a form of intellectual property. There's copyright, which is what we're going to talk about today because that's what dissertations, theses, and reports do. And there's also trade secrets. So like the recipe for Coca-Cola, or the Colonel's secret recipe for the breading on the fried chicken. Those are trade secrets. So those are all intellectual property. So we're only going to talk about copyright, but the same sorts of things or different provisions apply for things like trademarks and patents. So we're kind of keep focusing down. So things that are protected by copyright include works of authorship. So things like a novel, a piece of music, a play, audiovisual, things like music, all that sort of stuff is copyrighted. But in order to be copyrighted, it needs to be original. It needs to have creativity, and it needs to be fixed in some kind of medium. So actually, the presentation that I'm giving you today, because I'm recording it, it's original. I made it up. It's creative. I had to create the slides. I made figures. I decided what order they'd all be in. And it's fixed because I've recorded it. So my presentation itself is considered a copyrighted work, regardless of whether or not I send it off to the government to say it's copyrighted. So it needs to be saved. And I mean, sometimes we use the example of, I wrote it on a napkin. It doesn't matter how permanent the thing you fix it in is. If it's fixed on some physical way, then it is, or digital way, it is actually copyrighted. The big thing is it needs to be original, though, and creative. Those are two pieces that are really critical. So things that are not protected, however, by copyright are ideas, facts, discoveries, data. Copyright protects the creative expression of those, but not the idea itself, not the data itself. So we'll go through some examples of what this means as we go through this talk. So for example, a couple of ideas here. An idea of Vikings invading Mars is not copyrighted. And then the novel itself that we write about Vikings invading Mars, however, would be. The idea of a story about a bunch of friends in New York who hang out and have fun and laugh together is not protected by copyright. And if it was, we only have one show called Friends instead of like 30 million, right? We've got Friends, we've got Seinfeld, we've got Will and Grace, we've got, I don't know, Two Broke Girls. They're in Brooklyn, but they're broke too. They're all friends. And so all those sorts of ideas that we have, if you think about movies, boy meets girl, girl breaks up with boy, boy makes up with girl. That kind of, romantic comedy type of idea is not protected by copyright. Otherwise, we'd only have, one Pretty Woman, and we wouldn't need any more because we have done it once. Facts like dates on holidays on a calendar are not protected by copyright. But if I take those dates and go around and take all these pictures of the bridges of Michigan or lighthouses or something else, and then I put them together in a calendar, that's protected by copyright. Data that's in a table is not protected by copyright. It's just a listing of numbers, things in the phone book. All that kind of information is not protected by copyright. But now if it's original and creative, it can become a copyrighted work. There are exceptions. I don't want to talk a lot about this, but there are licenses. So libraries will pay to view things and license them. When you create a journal article, you will enter into a licensing agreement with the journal publication, and that will give you certain rights to reuse materials. When you submit your dissertation to the graduate school, you will enter into a licensing agreement that you sign on Digital Commons that says kind of what rights you still have with your work and what you don't. And you pretty much still have all of them because we don't own the copyright to your work when it's done. You may also have seen Creative Commons licensing, particularly on the internet. Maybe somebody's made a Creative Commons video and they're like, you can freely share this with anybody, or it might say you can freely share this with one person, or there's all sorts of rules about that. And then there are materials that are in the public domain, maybe because their copyright's expired or because the US government's created them, or maybe they're already public domain. So the example part is where I'm going to spend a little bit of time talking about some things that students often do. And the first one is a literature review. So you might want to summarize papers by yourself and others. You use your own words, or maybe a small quotation here and there, like a sentence or a sentence or two. Ideas are not copyrighted. So if you have 6 papers in front of you that present ideas on how to use bone cement and hip replacements, and you've taken those ideas and you summarize them in your own words, it's now your creative expression of those ideas. And so ideas are not copyrighted. You don't need to ask the 6 journal articles for permission to talk about their ideas in your paper, but you would need to cite them. So in the case of a literature review where you are creating your own expression of the technical field that you're working in, you don't need permission to do that. This is a common question I get after this presentation, so I've actually added this time, because many students start to think that they need permission for lots of things they don't. Excuse me. Another thing students commonly use are data tables. So maybe they find a table in a paper, and that table is listing some material properties, and they want to put that in their thesis. Data is not copyrighted. There is nothing unique about this table. If you gave me this table, I would probably just type it in the same way. There's nothing I can, maybe I would alphabetize them instead of putting them in some numeric order. I might change the order, but there's nothing unique or creative about the expression of this. So this is generally not considered to be copyrighted, and you should generally be considered okay to actually just take a screenshot of this or to just plop it in and again, citing it, because the original source should always be cited. But something like this is not considered copyrighted and does not require typically permission. The other thing that I see often is a simple graph. And data, again, is not copyrighted. This is a different way of presenting the data. Instead of a table, it's a graph. But, you know, we've got circles and squares and triangles. Maybe I would use red, blue, and orange. Maybe I would use a diamond instead of a triangle, but there's not a lot of creativity. And sometimes when people come into my office, I'll give them like a set of data, and I'll say, well, you graph this set of data, and I'll graph this set of data. If we all took this data in this room, if we all had it in a Cartesian table, and we all plotted it, probably all the graphs would look really much like this. There wouldn't be a whole lot of creativity going on, because it's a data graph. So again, this is not a creative expression of data. Because it's not creative, it's not covered by copyright. And so things like this, you should feel relatively secure in using without asking for permission, because they're not creative expressions. Yes, sir?
Do you have to replot it yourself to use that graph? Or could you just use the graph from there?
So the question is whether you need to replot it or whether you could just use the graph. And I would say you could do either. Because if you replotted it, you could probably make it better quality than anything you could screenshot from the journal article. However, because this is a non-creative use of the data, there are many people who would argue that the figure itself, just as it is in the journal article, is not copyrighted. The article itself, the layout of it, how it's expressed, where the figure is on the page is copyrighted, but that figure itself is not creative or unique enough to be considered, generally speaking. And again, everything I say I'm qualifying with generally, because there'll be one person out there who will argue and who will go to the courts. But generally speaking, the consensus on this is that it's not creative expression. It could be just copied and pasted as it is. Yes.
If I wanted to add more data on that graph, I could still do that.
Well, now that's adapted, right? So now you've adapted a figure that somebody else has in the literature. So if you add data to an existing plot, or if you add explanation or additional things, now you've adapted it. If you adapt that figure enough to be considered your own creative work, now you own the copyright to it. Or if you're just adding data points, maybe it's still not copyrighted at all because it's just so simple, no one would really care about that. So adapted things, if you've done enough to make it your own, are now your own work. And we've all seen examples where people remix music, and they take, you know, one little measure of a piece of music and create a new hook out of it and have that sampled throughout the whole piece of music. And that's okay, people do that. But then there'll be one person who goes, you took one measure too many, and then that goes to court. There's a recent one about like Stairway to Heaven. There's, you know, that's a big one that people like to sample and all sorts of things. Okay. Yes, sir.
How about figures?
Oh, that's the next one. Got you covered. So now we're going to talk about a figure. Now this one, I helped create the first one like this. I think I'm a co-author on this paper. I can't remember now if I'm a co-author on this one or one of the other papers in this area. But I can tell you that this is some data of a scratch test that's done on Dr. Mischiagu's indenture, I believe. And the data is lined up with the scratch and matches the actual scratch. We've got some labels on there that we've added. And so now there's some creativity here. We've actually added a photograph. We've had to select where that photograph is. We've had to line it up with the data. You know, it's not just any old person would do the same thing, because maybe we'd use different contrast or a different scratch or a different arrangement of the things. And this might be a gray area. Some people might disagree with me, and we're all allowed to do that. But I would consider this in general a creative expression of information, because it's now combining a photograph and data in a unique way that is creative. I had to spend a fair amount of time doing this the first time I did it, because it wasn't trivial. And so I can say that, yeah, if you use that without kind of asking my permission, I might be a little bit annoyed. Dr. Keith is actually the main author, so maybe he'd be the one to ask permission, but you know, as a journal. Even if they cite you. Citing is not, so citations show where the original source is. A citation is showing who created it. Doesn't mean you have permission. Citation is like the keys are in the ignition. Doesn't mean you can drive away with the car. Okay. And again, if we're going to talk about photographs or art or figures that are, you know, maybe more complex, these are generally considered creative expression of information. The composition, the camera settings can all be chosen by the photographer. I've taken a lot of scanning electron microscope pictures in my time, and you know, you've got the working distance, you've got how you prepare the sample, you've got what part of the sample you look at, how you code it, if you don't code it. There's all sorts of variables that go into creating those figures and creating those photographs. Picture on the right is one that I took myself, so right in Charlesworth. I've acknowledged myself as the person. And you know, if you use my picture of the Traverse Bay Winery, I would probably be a little annoyed. But you can go take your own. Beautiful place. Traverse City is beautiful. Software screenshots are also quite commonly used, and I would argue in most cases that these screenshots contain icons that you did not create. You did not create the home tab and the insert tab and the save button and all that sort of stuff. And so generally people would consider screenshots to be protected by copyright. So things like screenshots, figures, photographs, that sort of stuff starts to go into the, I probably need to get something else to use this in my dissertation. Anything that's created, protected by copyright, we'd need additional documentation. So what do I do? So I've gone through some simple examples. There's a lot more resources on the web. If you want to just Google, can I use it in my dissertation, you know, whatever it is, you can find lots of different opinions about that, and I'll give you some access to some additional resources through this presentation. But if you've decided that it's created, that it's protected by copyright, whether it's your own work or whether it's somebody else's, there are additional things that you need to do. So can you use it in your document? You can, but only if you have permission. And that includes your own published work. And we'll talk about that in a separate section in a little more detail. But like journal articles and conference proceedings, you need the permission from the copyright holder in order to use copyrighted materials. You would always cite the original source. If you don't, it's plagiarism. Citation is citation, citation. You must cite materials that you did not create You must cite materials that you published at an earlier point in time or a different point in time. Even if you created it, you need to make sure people know that this is not the first time this has been in print. So citing is the first step to any process of using materials created by others or that's copyrighted. And it's a scholarly expectation that applies even if the material is your own work that's been published. For figures and tables, we would recommend that the citation be in the text and in the caption. The caption itself for any figure or table should tell the reader that, yeah, this isn't my figure, it's for somewhere else. So the caption should allow those materials to stand on their own. I saw a hand raised over here.
Yeah, I have a question with citing our own work. So even if we have permission from the journal itself, and we have cited it, do we have to rephrase the work?
My classic answer is it depends. So if you have permission from the question is, and I'm saying it again because sometimes you can't hear on the online. The question is, if I cite my own work, if I have permission to reuse my journal article in a paper, do I have to rewrite it? And the answer is it depends, because it depends on what permission you got. If the permission you got was to reuse the material as it is, then you can reuse it. If the permission is to rephrase it, then you'll have to rephrase it. Now, it's kind of odd to get permission to rephrase. They would just say you can't reuse it, usually. They wouldn't give you the permission. So typically speaking, if you've gotten permission from a journal article, journal publisher to reuse your material, it's that you can reuse it. But you would always cite it because the original journal article is, people should know that it came from that original source. And it's not, this isn't the first time it's been published. So citation alone is not sufficient. It acknowledges that your document's not the original source, and so that's a proper attribution thing and an allegation of plagiarism, but it doesn't give you permission to use the material. It's like having the keys to somebody's car. Just because you have the keys doesn't mean you can go on an epic road trip. You know, you'd have to ask permission. You know, I have the keys. I've given you the keys so that you can get into it and maybe so you can move it around for me to do this limited stuff. But, you know, I can't go on a road trip to, you know, Florida with it just because I have the keys.
What if it's submitted and not published yet?
We'll talk about that in the next section. Okay, we're talking just about other work right now. So once you've cited it, you need to determine if permission is needed. And we've talked a little bit about that with the example. So things that are creative, things that are unique, things that are a substantial amount of text, you would need to get permission for. Now, permission is not needed when something's in the public domain or when the copyright's expired, or if you judge it to be fair use, which we'll talk about at the very end of our talk, or as we've already talked about, if the figures have been substantially altered. So if you've adapted a figure from a source and you created your own thing, then you don't need to ask permission, generally speaking. Now, the caption should let you know that this material was adapted, because otherwise it looks like it's just brand new and original and you just made it up. So if you've actually adapted it, the appropriate caption would be adapted from by citing the original source. And again, in papers, if you've retained the right to republish, you don't need permission. So first I have to decide, do I need permission? Is this something that is, you know, I don't have the rights to reprint it, it's unique, it's original, it's all these things, but I really want to use as my dissertation. If you need permission, the guide has additional documentation on that, but it must be in writing. Email or fax is fine. Paper letters, if you want to use paper still, like all that's good. Many journals will have an online way of doing this, so you can go online and you can just fill in a little web form and it'll generate a letter for you on the fly. That's what most journals kind of do as a standard practice. The next most common thing I've seen is for people to actually have to email a journal editor or the copyright holder and get permission via email. Our rule in the graduate school is if there are signatures on any pieces and you want to put them in your dissertation thesis or report, they must be what we call redacted, and that obscures them. And that's to help prevent identity theft. As much as we can, we try and adhere to some good practices with that. And we'll talk about how to do redaction in the next seminar, which is about Adobe Acrobat. And then you want to document that you have the ability to reprint. And again, the guide has additional information on that. Sometimes your rights holder will ask you for special things. So they'll say, we want you to put a certain credit line in. They might ask you for an embargo of your work until a certain period of time. And the graduate school will need to see all that documentation. All that documentation needs to be sent to the graduate school. And I'll talk about how to do that next. So what do you need? Well, documentation could be permission letters, or it could be your explanation that this material is in the public domain. I don't know by looking at a figure whether or not it's in the public domain, and it's your responsibility for every piece of material that's in your dissertation to know, do I have the right to reuse it, or is it in the public domain? That's your job as an author. An author's responsibility is to fairly represent all their sources, to write all the things with citations, and to make sure they have permission where they need it. We don't know by looking at it if it's fair use, but you might go through a fair use analysis and say, you know what, this is a fair use. And I'm perfectly okay with fair use. If we ask for permission to reprint everything in the universe, then publishers would expect that we would do that all the time, and we shouldn't have to. When we do movie reviews on a TV show, there's a permission fair use clause that allows you to use a movie clip on a TV show to say, this is a movie I reviewed. And that's how we can do critique and analysis, and how we can work together as a community of scholars to further knowledge. So just asking for permission for everything is not the answer. Fair use is perfectly acceptable. We just don't know that you've made that argument unless you tell us you've made that argument. And again, there might be some things that have expired copyright. Some of our researchers work on materials that are quite old, and there might be materials from the 1900s where the copyright's expired. But I don't know by looking at it that you've made that determination. So you need to explain that. So your documentation that you submit to the graduate school could be a bunch of permission letters, or it could be a bunch of explanations, and either one of those is fine. You would want to organize that documentation, and we would suggest that you make it an appendix to your document. That way, when somebody downloads your dissertation or thesis, they'll see all of your permission letters or all your documentation with it, and that way everybody will know that you've gone through the due diligence to make sure that the materials are, that you have the right permissions for them. Your other alternative, the second best alternative, would be if maybe those materials are lengthy. Maybe it's 30 or 40 pages. Some of these licensing agreements from publishers could be quite long, and you might not want those all in your dissertation. So the second suggestion would be to upload them as a PDF document to ProQuest and Digital Commons. And both of those have ways of uploading as supplemental documents so that you can put those in there. If you have a really simple explanation, and it's like one sentence, and you can type a comment in Digital Commons, but that's pretty rare to do. But if your explanation is so simple, you really don't even want to waste your time making a PDF document of something. One sentence, everything's fair use because it was created by the federal government. Good, that's fine. We would also want you to label all these materials because nobody wants to look through 40 pages of licensing agreements without knowing what it's for. So a simple label like this is for figure 4.5 or this is for chapter 2 or whatever it is, just a little like label somewhere. And again, to remove your signatures. So cite your material. Figure out if you need permission, because you don't need permission for everything. If you do, get permission. And then put all that stuff together in one packet. Okay? So what if it's a journal article that you've already published? In the graduate school, we define a published paper as anything that's in print, accepted, in review, planned, submitted, all that kind of stuff. So when I talk about published papers in this presentation, that's what I mean for right now. However, only things that are in print are copyrighted by the journal. Until it's copyrighted by the journal, you still own the copyright. And so only in print things require your copyright documentation. So can you use a paper that you've already published in your document? And the answer to that is, well, yes, if you have permission. And in the guide, we talk about how you can organize those sorts of documents. and how you can do that work. And this does include your own published work published by others, internet, screenshots, always cite things. So again, it's the same exact thing we just talked about. Always cite the original source. So if you're putting in a journal article that you published or that's in preparation or that's in a review, you would cite the source. It might be that it's planned for preparation. It might be that it's actually published. Figure out if you need permission. And this is where it's really important now. You want to look at the copyright transfer agreement. So when your journal article is published, somebody signs over a copyright transfer agreement. Now, in the olden days when I went to school, which wasn't that long ago, I'm not that old, but it was a while ago now. In the olden days, your advisor would sign the copyright transfer agreement, and he had to actually walk it around the lab and get everybody else to sign it who was a co-author on the paper. And so when I signed that agreement, I would read it over and I would see, what am I signing my life away to? Nowadays, most of the time, these are click-through agreements that when you upload the paper to the journal online, you'll click through and say, yes, I agree to this. And it's usually available for you or emailed to you, but if only the corresponding author might have access to it. And they might be signing off on your behalf. So you might need to ask your advisor or the corresponding author, what's the copyright transfer agreement say? Because that agreement may already say that you can reuse the paper. And you might not need to do anything else to use that paper. It might say you can never use the paper, in which case you know you can't reuse it. It might say something else in between. And so whatever that agreement says, you've signed off on it, you need to abide by it. If you don't have that information in your copyright transfer agreement, then you might need to obtain permission and then again document all that for the graduate school. So we've already talked about this, but the copyright transfer agreement is something that authors sign. The authors own the copyright to the article when you write it. So in order for the journal to publish it, they need your permission to start with. And that's the whole part of how permissions start. The journal needs your permission to publish your work, and now they allow you some rights to reuse it. If it's your published paper, and again, for purposes of the graduate school, published papers would be anything that's in review, press, submitted, accepted, all that stuff. You would add a footnote to each chapter or section, and the guide has suggested text. And you might need a credit line from your publisher. We would also require that you add an author contribution statement to your document. That was formerly called the preface in some previous versions. So if you've downloaded an older version of the template, it'll have preface in it, and that's the same thing. It describes the contribution of all the authors, including yourself. Does not need to be long, but contributions would include things like writing the paper, analyzing the data, planning experiments, collecting data, whatever the contributions might be for that particular person. So there's also something we've talked about called fair use. I've kind of thrown this word around a couple of times. But fair use allows the use of some copyrighted materials without asking for permission. And this is really designed for, if we didn't have fair use, we wouldn't be able to have book reviews, we wouldn't be able to have music reviews, we wouldn't have movie reviews. All those things are reusing copyrighted materials. They'll play like a 10-second clip of a music song when they're reviewing it, because otherwise the reviews would be kind of boring. It's like, it has a great beat and I can dance to it. I mean, that's, American Bandstand type of review. It would be a horrible review. And there's a 4-factor test. And it looks at what are you doing with it, what's the nature of your reuse, the amount, the market effect. It's a case-by-case application, and it is ambiguous by design. The federal government does not want to tell you exactly what you can and can't fair use. They want it to be gray, because the boundaries of what it is should shift and change over time as people evolve and as music evolves and as technology evolves. And if it's challenged in court, it would be decided, if it's challenged, it would be decided in court. You can find lots and lots of these. Music sampling is a big place where this happens, where somebody will say they sampled too much of the music, and somebody else will say it's just fair use, I can use 4 measures, I can use 2 beats, I can use whatever. There's a lot of debate about this. You'll find tons of court cases about it. It's kind of interesting. Once you know about it, and you start seeing the headlines in the news, it becomes rather interesting to follow some of these cases. But as an example, here's a picture. Maybe I want to have this Bridges calendar. So I'm going to make my own Bridges calendar. And I found this picture on the internet. Of course, it's me, but so it's my picture. Interestingly, though, it might not be my picture, though, because who's holding the camera? The person holding the camera is actually the person who owns the copyright, because they're the ones composing the photo. We use a timer, so we're good. It's my photo still. But let's just say we found this on the internet somewhere. It's on somebody's webpage, the fabulous photos of London Bridge, and we're all excited. We're going to do a calendar about the bridges in England, maybe, because I like England. So is your use transformative? Am I transforming the world with it? Am I borrowing from fact or fiction? Borrowing from fact? That means it's more likely to be fair use. Borrowing from fiction, less likely. How much am I using, and how important is it? If I'm using the whole thing, then that's not very fair. If I'm using a little bit, that's fairer. What's the potential market effect for the copyrighted work? By me putting this photo in my calendar, am I depriving the copyright holder of making a fortune on it? Or am I actually going to increase sales? Because now everyone's going to want to see my work. All these factors, and they shift back and forth, and there's multiple ways to interpret all of them. And at the end of the day, if all of them kind of lean towards fair use, then we can say it's fair use. Now you might be saying to yourself, well, this sounds kind of complicated, and it kind of is. This is the ambiguous part. This is what the law allows for. But there are tools. So on our website, we have some links to them. They're called, there's some fair use evaluator tools. And what this tool will do is it will ask you those 4 questions, and it'll give you some examples and some ideas, and it'll give you a little thought process for you to think about it, and kind of on the slider of how fair or unfair you think the use is, or how fair or protected. And at the end of it, it'll give you like a little summary. Well, based on the way you answered these questions, we would say your use is probably a fair use. Now, again, this is not a legal tool. It's not providing legal advice, but it's one way for you to kind of look at things. And often people say, well, it's education. I'm doing facts, and I'm using it for education, and I'm transforming the world with my knowledge. So education. But education is only one of the 4 factors, and that's why you can't just say it's because I'm using it in my dissertation. It's not okay as a single reason. It's part of the reason. It's one of the 4 parts, but it's not the whole reason you can do that. So our website and if you go to the seminar page that I discussed at the beginning, it's got a lot of links to these different materials. But we do have an FAQ on our website. We've got a lot of resources. So you'll find this fair use evaluator. You'll find some copyright help. Nora Allred is the university's copyright librarian, and she is available to assist students. I can help with a lot of really simple questions because I get a lot of the same ones over and over again. But occasionally there'll be a case where it's like, that one's a little more complicated, and I don't feel comfortable giving you advice. And Nora's seen a lot more things than I have, so she's another resource to help you. And so that is copyright in your dissertation, and I can answer any questions on that. And I'm going to stop the recording now just so we don't have the questions on tape.